Welcome to Guidepost and Steptoe's webinar, Data Under Watch, Navigating DOJ's New Rules on Sensitive U.S. Data Transfers. I'm Bradley Disick. I'm president of Guidepost Emerging Issues and Technology Practice. I provide crisis management counseling and specialize in leading large-scale, sensitive, and cross-border investigations. I've conducted investigations in over 36 countries, including those that involve data transfers. Global Investigations Review included me as the sole American-based investigations consultant on its list of the top 40 under 40 investigation specialists worldwide. We also have David Moncure with us. David recently joined Guidepost and is an AI and data governance, privacy, and security and e-discovery counsel with experience supporting multinational Fortune 500 organizations, in-house law firm, and now consulting settings across various industries. David is a managing director in Guidepost Solutions Technology Advisory Services Division. He develops, manages, and monitors the creation, implementation, and maintenance of large data governance programs and assists with data privacy and security and e-discovery consulting engagements. We are joined today by Ross Weingarten, a partner in Steptoe's Investigations and White Collar Group in New York. Prior to joining Steptoe, he was a federal prosecutor for 7.5 years, first in the Northern District of California, and then the District of Connecticut, where he prosecuted all types of federal criminal violations with a focus on white-collar crime. Ross graduated from the University of Texas Law School in 2013. So to kind of just set the stage, I'm going to talk a little bit about what this rule is and where it's coming from and why it's currently relevant. The United States Department of Justice recently announced that it will begin enforcement of these sweeping new rules regarding the transfer and storage of sensitive U.S. data in July 2025. The rules prohibits transfers of sensitive personal data and U.S. government-related data to certain countries of concern and persons affiliated with those countries, either directly or indirectly. Violations of the rule can result in significant criminal, civil penalties for individuals and corporations. The new rules also mandate certain due diligence and auditing requirements, as well as contractual language when engaging in data transactions with any foreign party. While initiated under the President Biden's Executive Order 14117, the Trump administration is poised to fully implement and enforce the rules. The DOJ's National Security Division promulgated the final rule, EO 14117, codified at 28 CFR Part 202 on January 8, 2025. On April 11th, the National Security Division of the Department of Justice issued a compliance guide listing over 100 frequently asked questions and an implementation and enforcement policy for the first 90 days. While the NSD has long played an important role in prosecuting criminal violations of national security-related laws, it has not historically acted as a regulator in the area of technology or data transfers. As it is now, it will do so. So Ross, I kind of want to actually talk to you about that. Can you talk to us a little bit about the data security program generally, but also maybe talk a little bit about why DOJ and why the National Security Division?
Sure. Well, first of all, thank you, Brad. It's great to be with you. It's great to be with David and my friends from Guidepost, and for everyone watching, it's really nice to be here with you on this afternoon. So, a couple of things. First, I think the data security program is going to potentially bring wholesale change to the way that American companies collect, store, and transfer certain types of sensitive data. So any company that's in the business of collecting large amounts of data, this could be consumer data, could be health data, could be financial data, is going to have to really sort of consider these new rules and ensure compliance with them. And generally speaking, what the rule does is prohibits or restricts U.S. companies, U.S. persons is how they phrase it in the rule, from brokering, transferring, storing, providing access to that sensitive data to 6 countries of concern, and I know we'll talk a bit more about those countries in a moment, and covered persons, who are generally people and entities connected to those 6 countries of concern. In terms of the program, I think it's what you said about this starting as a Biden executive order, and the Trump DOJ sort of taking this program and running with it is really important. I think it's one of the few things that over the first 5, 6 months of this administration, we've really seen the Trump administration build on the work of the Biden administration, which suggests to me that this is going to be a priority for this department. And in fact, Steptoe has heard that both internally as well as through public statements made by Deputy Attorney General Todd Blanche and others, that this program is going to be a real priority of this Department of Justice. So in terms of why the DOJ, it's a DOJ-run program because there are criminal penalties associated with violations of these rules. And as you know, Brad, only the Department of Justice can bring federal criminal cases, actions against individuals and companies. So this is being run out of the DOJ's National Security Division. And we'll talk about this more, I think, but remains to be seen exactly how enforcement is going to work and which components of the DOJ are going to be active in this space. But I can say with great certainty that this is going to be a priority. Enforcement begins in approximately 2 weeks. The rules, the guidance, and the FAQs that you mentioned in your opening remarks were released in April. And the Department of Justice basically gave everyone a 3-month grace period to come into compliance with the new rules. And that 3-month grace period ends on July 9th. And so starting on July 9th, the DOJ has said, we are going to begin civil enforcement of these new rules. And I expect that it will be fulsome.
I appreciate that, Ross. David, can you talk a little bit about which the countries are of concern and the feasibility of Department of Justice adding more?
Sure. Well, as you can see on the slide, there are 6 countries that the DOJ initially listed here: China, Cuba, Iran, North Korea, Russia, and Venezuela, as countries of concern due to their adverse conduct towards U.S. national security. But they also included in the rule that the list could change based upon determinations by the Attorney General, Secretary of State, and Secretary of Commerce, adding additional countries at a later time based upon the same analysis that they went through for these countries with the U.S. national security concern and data going into those countries that could be misused.
I appreciate it. Can you maybe talk about what and who a covered person would be?
Yeah, sure. So a covered person generally could be an individual or an entity. It includes persons located physically in those countries of concern. But it also includes a series of other entities. They list foreign entities 50% or more owned by a country of concern, foreign entities 50% or more owned by a covered person, foreign employees or contractors of countries of concern, and foreign individuals primarily residing in those countries. So they don't have to reside there full time. They can reside there most of the time. And then as with the countries of concern, the DOJ said that any person or entity, regardless of their location, if determined to be controlled or under the jurisdiction of a country of concern, could become a covered person as well.
I appreciate that, David. Ross, can you kind of maybe talk us through a little bit about what the rule prohibits, restricts, and maybe a little bit more context?
Yeah, sure. So first things first, the question is, who does the rule apply to? And the answer is U.S. persons. And, that includes all U.S.-based companies. And Brad, maybe go back one slide. So all U.S.-based companies and U.S. individuals as well as foreign branches. And so if a US company has a branch, say, in France or the UK, that branch would also be subject to these data security program rules. So it's not enough to say, okay, we're going to have entity um, our foreign entity transfer data to our Chinese partners or something like that. That won't work. The rules do treat subsidiaries differently. So a subsidiary of an American company located abroad would not be considered a U.S. person under the rules. But what gets tricky is a subsidiary of a U.S. Company that's located in a country of concern could be a covered person. So companies may find themselves in the position where they're a U.S. company with, say, a Chinese subsidiary, and then you have a U.S. person, the U.S. parent, and a Chinese subsidiary that could be a covered person under the rules, which would make intra-company data transfers virtually impossible. And so, companies in that position need to be aware of these rules. So who do these rules apply to? U.S. persons. So any company, any general counsels on this call who work for U.S.-based companies who collect and share data with foreign counterparts, these rules apply to you.
I'm on mute. Do you want to talk a little bit about, David, the types of regulated data?
Yeah, sure. So there's two main types here of regulated data. First, government regulated data. It's any volume of data that could reveal insights about U.S. government locations or personnel, including geolocation data for areas designated by the Attorney General, such as military installations or intelligence facilities, and sensitive personal data that are linked back to U.S. government employees or officials. The much broader list is the second thing here, bulk U.S. sensitive personal data. There's a lengthy list of various sensitive data divided out into 6 basic categories, as you can imagine, first related to health, and then this financial data, precise geolocation data. And they break it down into the number of individuals that would be impacted. So for example, human genomic data of about 100 individuals or more would qualify. Biometric identifiers of 1,000 or more individuals would qualify. Precise geolocation data of 1,000 or more individuals would qualify. And then it goes up for health information of 10,000 or more individuals, height, weight, vital signs, symptoms, test results, financial information of 10,000 or more individuals, bank account information, credit card information, and then covered personal identifiers of 100,000 or more individuals, which would include commonly linked things such as government ID, social security number, full financial account number, and the like.
Appreciate it. So we have a couple Q&A that I kind of want to take, as we go through this. So, Ross, I think you can take this one. When you say companies, does that include nonprofit organizations?
Yeah, absolutely. So nonprofit organizations are subject to these rules. Individuals are subject to these rules. So there are certain exceptions and licenses that we will talk about a little later. The U.S. government is one, obviously. So sort of U.S. government, day-to-day operations are not covered by these rules, but certainly nonprofits that collect and store and share data are subject to these rules.
I appreciate it. And then David, maybe you can help take this question is what kind of companies have a legitimate need to send U.S. Personal data to the 6 countries of concern? Like, why would they be transferring the data to China or Hong Kong, for example?
Yeah, you often think about that, or we've talked about it in terms of industry. So if you say you have your life sciences or biotech, there's frequent cross-border R&D and clinical data flows that are going. When you look at healthcare and insurance, the health and biometric and geolocation data is often going to exceed those thresholds that I mentioned. when sharing information. Financial services obviously is a big industry that would be impacted here with relation to the financial information of 10,000 or more individuals. We look at tech, cloud, social media, where you have biometric, geolocation data there as well. Same would apply to the telecom industry as well for the geolocation data. And so those are kind of the main industries. I don't know, Ross, if you had any others that come to mind, but those are certainly big ones.
Yeah, David, I think you nailed it. Though, life sciences, healthcare, financial industries, consumer-facing industries that are collecting data from customers, I think are all going to be impacted by these new rules. I'll just say one other thing, which is we are already advising clients on these new rules and how to make sure they're in compliance. And what we're hearing is a couple of things. Number one, because of sanctions regimes, I think it's fair to say that most U.S. companies are probably not regularly doing business with Iran, with Cuba, with North Korea, and perhaps with Russia and Venezuela as well. But it is certainly the case that a lot of U.S. companies deal with Chinese counterparts regularly. And so China is the one that stands out, I think, to the folks who we have spoken to as a potential concern. So that's number one. And number two, David, getting back to your description of what a covered person is, it's not just as simple as saying, oh, we don't send data to counterparts in any of the 6 countries, so we're fine. If you look closely at the definition of covered person, it can be a company, Acme Corporation that's based in London, but that is 51% owned by a Chinese parent. Would be a covered person, right? And so companies sometimes go to great lengths to obscure, their true ownership. And so what I would say to everyone listening right now is you have to be really careful when you send your data abroad, particularly if it's, data covered by these rules. And I would strongly suggest calling David, calling Brad, calling me if you have any concerns about whether or not your normal business practices are going to run into these new rules and potentially cause trouble down the line.
So Ross, that's like a really good segue. You're already advising clients, as this rule, come close to requiring compliance. I think it's we're 2 weeks away now. Can you talk a little bit about, key compliance questions? I know we have other topics to talk about here, but kind of, halfway through, maybe talk about some key compliance question, and then, I'm going to encourage the audience to send in their questions so we can kind of maybe, flush out some specifics that may apply to them.
Yeah, absolutely. I mean, I think, there's sort of a checklist, and Steptoe published a white paper about this, which is easily Googleable. And in the white paper, just as on the slide, we have a pretty good checklist of questions that companies should be asking. The first one are, do these rules apply to us? So are you a U.S. person? And I assume that most of the people in this webinar, the answer to that question is going to be yes. And the second is, the data that we're sending out, is it going to a covered person or a country of concern? And so what we are doing for a number of clients are sort of data mapping exercises, right? Where we are looking at their business practices and figuring out, okay, what data do they collect and where does it go if it leaves, the United States? And so you got to ask yourself, who are our partners and where are they located and what's their ownership structure? Next is the type of data involved. So there's 2 types of data involved, as David explained. The first is U.S. government data. That's probably more rare. But if you're in the national security industry, if you are a defense contractor, things like that, you might run into U.S. government data, and you'll need to be careful. But more common, I think, is going to be, sort of the bulk sensitive personal data. And so if the data that you collect falls under the rubric of either of those, you need to be aware. And then the rules set out different types of agreements, different types of agreements with foreign data partners that are covered. And there are four. So it's data brokerage agreements, employment agreements, vendor agreements, and investment agreements. And so if you are involved in any of those types of agreements, and all of those are defined in the rules, you need to be cautious as well. And then finally, the question, really, these rules are about access to data. That's really what these rules are trying to prevent, is access to sensitive U.S. data by countries of concern or people affiliated with those countries. And so as part of the data mapping exercise, we are asking ourselves, okay, do any of these covered parties get access to this sensitive data? And if the answer is yes, I strongly suggest, trying to make some changes now to the way the company does business. I forget what the expression is, but it's in for a penny, out for a pound, or a spoonful of sugar, or whatever cliche you want to use. Better to prepare for this now rather than getting a subpoena, which leads to a very lengthy DOJ investigation that is going to cause lots of stress and cost lots of money.
I appreciate that, Ross. And Dave, I'm going to get you in a second to kind of talk about, some of the data management strategies that folks can take. I think, Ross, one of the things that you really talked about that kind of hit home with me was like 15 years ago during the financial crisis and coming out of that in Dodd-Frank, we did these living wills and we did these resolution plans. And a big part of that process was this mapping. So I think that's, excellent advice, especially for corporations that are a little larger and might have, different entities all over the world that, may be impacted by this rule and could run afoul of it. But we do have a question from the audience that I do want to get to you. And Ross, maybe you're the best person to take this, is what about the issue of deemed exports? If you have an individual from a country of concern working in a company that generates data covered under this rule.
Yeah, it's a good question. To answer it, I would probably need to know a little bit more about the facts and the specifics. Look, everything that we're talking about today is going to be a fact-intensive inquiry, right? And the rules are very broad. And as David said, I think they're going to cover a lot of different industries and a lot of different types of companies. We haven't even talked yet about data transfers to all foreign partners, not just the 6 countries of concern. So without dodging the question, I think my answer is if an individual from a country of concern is working at a company and they are generating data that's covered under the rule, at the very least, that company needs to look carefully at the rules to ensure that their situation complies. I think these rules, we haven't even talked about this, but are going to impact company organizations and where certain types of employees in companies can sit. If you have your accounting department in China, you might want to think carefully about that, depending on what kind of business you're in.
All right, I appreciate that, Ross. So, David, I want to turn back to you a little bit to talk about, Ross has talked about, doing this mapping exercise. We're thinking about, integrating this into our risk assessment so we can kind of comprehend, where all of our risks sit related to this rule. Maybe you can talk about, some of the operational and related data controls.
Yeah, sure. Just from a practical standpoint, there's a theme throughout the document that was issued, and it's companies need to know their data. I think Ross has said it several times now, and you can glean from what Ross has said in describing the rule itself. Companies need to understand the kinds and volumes of data that they're collecting on or maintaining about U.S. persons, U.S. devices. How is the data used? Whether the company is engaging in these data transactions, just how does the data flow within your company? If you don't have those data inventories or you haven't done the data mapping, those are questions that you can't answer. And I think just from a practical standpoint, it's taking that low-hanging fruit. The easy things to do are developing the data inventories, the data maps, training the employees who are using this data about this rule and about the transfer obligations, and conducting internal reviews and conducting internal audits, understanding that not only are you writing down on a piece of paper that you are complying with this, but it is actually happening in your company. No different than things that we have done for decades now, related to other record keeping requirements, basic data governance programs, basic compliance programs. Yes, this adds another layer to it. But those basic hygiene elements that we've done for many, many years apply here as well. And now, we'll talk about later, what will enforcement look like? Who knows? But we can say with certainty that if you don't have those basic elements, that enforcement won't be good for you.
Hey, David, such an important point. And let me just piggyback off what you said to make sort of two related points. One is, I think a lot of US companies will have already done some of this work already if they operate in Europe. Because Europe, with the GDPR and other regulations, I think has historically been ahead of the US in terms of regulating data security. So my guess is for at least some companies and some folks in this webinar, some of this work already exists, which is good, in that you can leverage that work to be in compliance with these new US rules. So that's number one. And then number two is, I think that what you said in terms of enforcement is exactly right. We don't know what it's going to look like. But one thing I am pretty confident about is this Department of Justice has emphasized, perhaps even more than their predecessors, the importance of voluntary disclosure and remediation. And so companies who start this work now, in earnest, start these compliance efforts, start these data mapping exercises, start their auditing, and show real effort to comply with these new rules and understanding of them, hiring great outside counsel like Guidepost and like Steptoe to help. If and when the DOJ comes calling, I'm quite confident that the work that is already put in is going to be a significant mitigating factor.
Yeah, I appreciate that. We recently had a couple, DOJ inquiries for clients where, we worked with them with counsel to do prevention programs. And when DOJ came in and kicked the tires, we were able to work with counsel to get our clients' declinations. So, that's a fantastic point, Ross. So kind of, moving on, couple slides. Ross, can you talk a little bit about prohibited versus restricted transactions?
Yeah, absolutely. So this is something we haven't talked about yet, but I think it's critically important and sort of something about these rules that's not talked about. Prohibited transactions are what we have already been discussing. These are transfers of covered data to countries of concern or covered persons. Absent a license, and I'll talk briefly about that in a moment, absent a license, US companies can no longer do data transactions of that sort. So those are prohibited. The rules do contemplate a licensing procedure. So there are general licenses for certain types of transactions. For example, data exchanges that are incident to normal payment transactions are not going to be covered by these rules. Things like that. There are others about academia where there are sort of general licenses. And one thing I would urge companies to do is to take a look closely at the categories of general licenses and see whether or not your data transactions fit into one of those categories. And of course, we can help with that. There's also a specific licensing regime where companies can apply for essentially a one-off permission to do a data transaction or a certain type of data transaction. So this is similar to like an OFAC sanctions regime where you can go to the Treasury Department and request permission to do something. Here, you would go to the Department of Justice's National Security Division, and you would explain what you're trying to do and seek permission to do it. I think it remains to be seen how generous the DOJ is going to be with those licenses, how much time it's going to take for them to either grant or deny those licenses. So, data transactions that need to happen quickly. If you're going to seek a specific license from the department, I would urge everyone to start thinking about that now. So those are the prohibited transactions. There are also transactions that are restricted, meaning you can do them, but there are certain new rules that you have to follow. And the one that I think is most important and is going to impact a whole host of U.S. companies and U.S. industries is now any data transaction to a foreign partner that is covered data that we've been talking about, you now have to include contractual language with your foreign partner, basically saying to the foreign partner, even though you're, let's say, a French company, you agree to follow essentially the data security program rules with respect to that data. So you have to get your I'm making this up, but your French partner, your data transacting partner, to agree not to then turn around and give or sell that data to a country of concern or a covered person. But the contractual language is not enough. U.S. companies are now required under these rules to do their own due diligence, to take reasonable steps to make sure that their foreign partners aren't going to then turn around and give that sensitive U.S. data to bad actors in the countries of concern or connected to those countries. So this is a big change. And so even if you're a company that says, well, of course we don't do business with Iran and North Korea and Venezuela and Cuba, who would do that? But we do data business with foreign partners. You need to be aware of these new rules, and you need to start thinking about contractual clauses that are going to bind your partners and protect yourself should the DOJ ever start poking around.
I appreciate that, Ross. David, I don't know if you want to chime in a little bit about some of the compliance considerations around the rule. We've talked to a little bit about some of the data management considerations, but maybe we can talk a little about due diligence, reporting, record keeping, some of the other requirements.
Yeah, sure. Ross touched a little bit on the due diligence there at the end of vetting the vendors, employees, and partners, and also not only with that contractual language, but actually seeing about that continuing ongoing transfer. The interesting one of the interesting ones here is the record keeping requirement that these entities are required to engaging in these covered transactions must retain and complete accurate records for 10 years. And there's some additional documentation that's required for restricted transactions, including written and annually certified data compliance and cybersecurity policies, annual security audits and certifications, due diligence documentation, a lot of what Ross is talking about, with data types and volume being included as well. The agreements and licenses that DOJ referenced, or DOJ issued license that was discussed, annual certifications affirming completeness and accuracy of due diligence records. And a lot of this comes back to, like was discussed before, a written auditable compliance program, conducting annual audits on your transactions and on your data program, generally speaking. And as was mentioned before, training of the personnel that are using and transferring this data to. A lot of this does come back to, as we talked about, the basic hygiene of your compliance program. How are you updating the current program that you have to account for these rules as well? and updating, these new record keeping requirements are very specific of things that records that you have to create and maintain that you may not have been or probably weren't beforehand as well. And throughout all of this, with the compliance requirements, and when you look at this, it's really key to create for entities, if they don't already have one, a cross-functional team with representatives not only from legal to look at these legal requirements and implement it, but who else is going to help execute this within the company? People from IT, people from security, someone from your compliance program, and key business representatives as well from your key divisions that will be involved in transactions like this. And not only getting that group together to lay the foundation for enhancing whatever program you have or developing a new program, but maintaining that ongoing communication as your business evolves to make sure you are in annual compliance when you have to do these audits each year as well.
Yeah, I appreciate that, David. So, maybe one of the things that, we can talk a little bit about is the difference between a risk assessment and an audit. So, there's two different options of how to approach this and two ways to conceptualize, what are your risks. So one, you can look at a risk assessment, right? The risk assessment looks across, maybe the enterprise or, a specific type of activity, and it looks within that activity, which, may be data transfers, and identifies what are your specific risks that allow you to build a compliance program or internal controls around those risks. Audits allow you to come in and validate that the way that your program is in place, is it functioning as intended? And I think, maybe Ross, you can talk a little bit about how you guys approach, things like risk assessments and audits.
Yeah, sure. So what we've been doing for clients is trying to help them do exactly what you both said, which is understand the data, what type of data it is, how they store it, and who they share it with. And so, we are obviously highlighting the countries of concern. We are examining data transaction partners to identify risks. And we are trying to look under the hood to ensure that any data that's collected is stored securely and not in violation of these rules. So, I think there can be a number of different ways to go about doing this, but the long and short of it is that, getting a handle on these rules and doing an assessment internally and, with external help is the best way to ensure not only compliance, but also being able to go to the authorities and say, hey, look, we're taking this really seriously.
All right, awesome. Let's turn to enforcement. So actually, we have one question from the audience that I want to get to before we turn to enforcement. Can you give examples of the data? They asked if name and email, is that considered sensitive data?
It can be. I think so. Name and email is probably you're probably thinking about sort of bulk sensitive personal data. And as David explained, there are thresholds. So for that type of data, it would have to be 10,000 or more US persons. Would just name and email count? Perhaps not. But it might. And so, if you're in the business of collecting names and emails of US persons and then sharing them with foreign partners, I would strongly urge you to take a very close look at the rules, or ask David and Brad or me to do it, to make sure that number one, that's all you're collecting, and that there's not payment information or PII or anything like that. As well. So, for all of these questions, they're going to be fact intensive. They're going to be specific to the company or to the industry. And will require a very close read of the rules to ensure compliance.
Awesome. All right, so let's turn to enforcement. Ross, how do we expect enforcement to begin?
So this to me is the most interesting question, and I think we all wait with bated breath, maybe some less bated than others. But so this program is run out of the DOJ's National Security Division, and specifically their Foreign Investment section. So it's called FEARS. FEARS is typically an administrative and regulatory section. They don't typically litigate. So one question right off the bat is going to be, so if FEARS sends out an administrative subpoena, and FEARS does not, as far as I know, have access to grand juries, you would need to partner with a U.S. Attorney's Office, or in some rare cases, a criminal section in Main Justice. But so FEARS could send out a subpoena. They can send out letters. They can try to do interviews. And they can collect information that way. But if there's ever an instance where they need to litigate this, they're going to have to work with a litigating section within Main Justice or a U.S. Attorney's Office. So up on the slide, you can see the potential penalties. There are strict civil penalties for sure. And there are potential criminal penalties. The department has said they are going to reserve the criminal penalties for entities that sort of flagrantly disregard these rules or try to obfuscate or obstruct the rules. But nonetheless, there are criminal penalties on the table here. In terms of how it's going to work, my humble view, and this is something that I just am surmising from my knowledge of the department, having been in AUSA for 7.5 years, is there's no question that department leadership has said that this is a priority. Attorney General Blanche, Deputy Attorney General Blanche, in their announcement, basically said, this is a big priority of the department, and we're going to go after, foreign actors that are obtaining U.S. data, and we're going to go after the U.S. companies that provide it. I am of the view that enterprising AUSAs in U.S. attorneys' offices where companies that are in the business of collecting and sharing data exist, places like New York, places like San Francisco, and others, are going to take their marching orders from department leadership and start sending out grand jury subpoenas. And start asking companies in their districts where and how they store and share their data. Obviously, they would need some reason to do that, but you never know what reason they might have. So I'm of the view that this program is starting in the DOJ's FEARS section, but it's actually going to metastasize, and that other components in the DOJ are going to take it and run with it. I also think we may see some parallel SEC enforcement down the line, where publicly traded companies are asked to mark in their K's and Q's that they're in compliance with these rules. So I think this is going to be a priority of this administration. How exactly it's going to work remains to be seen. I think we're going to start to get answers in 2 weeks. But that's why this panel is incredibly well timed, because for the in-house counsels that are on the line, now is exactly the right time to start thinking about these rules.
I appreciate that, Ross. So, David, can you talk a little bit about, if you get a subpoena and the DOJ is asking you to, turn over information, how we go about collecting that information, how we go about transferring it to the DOJ, can you talk about that process? And then, Ross, I want to come back to you and ask an interesting question, because the DOJ is the civil regulator for this rule, which is unique, do you think there's going to be examinations?
Actually,
David, let you go first.
do you want to start, Ross? Because then I think I can follow on with our last slide too, and answer Brad's other question that might be a good follow on to what you're saying.
Well, sure. Look, I mean, again, I think that the long and short of it is we don't yet know what enforcement is going to look like. What I did as an AUSA, obviously, is try to gather information using the power of the grand jury, and interviews to sort of understand whether or not criminal violations took place. And I expect that's going to happen here as well. In terms of the civil regulatory regime, a lot of these rules were sort of taken from the OFAC sanctions regime and repackaged. So it wouldn't surprise me to see at least the regulatory side of things run sort of like how OFAC runs its sanctions regime. But who knows? And so I think, we need to sort of wait and see how the department is going to approach this. But again, this department is extremely motivated to prevent the transfer of data to foreign partners who, wish to do harm to American interests. And, this program is going to be the vehicle with which they do it.
And I think following on what you just said there, Ross, that's what they're going to come in and look for. So the documentation that your company has about its general data governance program, they're going to ask for policies and procedures. They're going to ask to interview perhaps your CISO, perhaps whoever, if you're a larger organization, if you actually have someone sitting atop a data governance program overall, and looking at the data mapping. If you have software that you're using to assist with that, they may ask for outputs of that to see how data is flowing from system to system and out of the US to potentially onward to companies of concern. They'll look for those vendor agreements. What are the contractual clauses, and how are you preventing data from ongoing in those transactional areas that Ross mentioned earlier? And the general training. What do those training slides look like that you've shared with employees that are dealing with this data on a day-to-day basis and who are charged with work in your entity around this? If it's the R&D data, if you're in a biosciences company, for example. And also, if you have applied for those licenses, what paperwork did you keep around that, and documentation that you are actually doing what you say you are doing with those data flows and having represented that. In reality, can you produce an audit that says, yes, I actually did this as well? Would be some of the things that I would think would be asked of your entity.
Appreciate that, David. So, we're going to wrap up here shortly. So we got about 3 minutes, and then we'll turn to Q&A. So if you have any questions, please populate them in the question box, and we'll about 10 minutes to answer them. So the time to do that is now. So kind of just to kind of refresh what we've discussed and re-go over what we've discussed. Companies can do to maybe prevent. You prefer to prevent than respond, of course. So in terms of prevention, conduct data mapping and risk assessments. As we talked about, risk assessments are different than audits. So you can conduct your audits, but without doing a risk assessment, you're not going to properly comprehend, where your risks are in the organization, and your audit program might even be affected by that lack of comprehension. So it's important to do your risk assessment. And if you look at the 7 pillars of an effective compliance program, a risk assessment is really that first step to comprehending, whether you are in line with the DOJ guidelines. Review and revise contracts. Ross, you talked about that. I don't know if there's anything that you want to contribute in addition.
Say that again, Brad.
With reviewing and revising contracts, is there
Yeah.
anything you want to...
Well, again, just that any current relationship or future relationship with a foreign partner from anywhere, does not have to be with a country of concern, from anywhere. If you share data with Latin American counterparts or European counterparts or Asian counterparts, you need to review and revise those contracts to include language essentially ensuring the security of that data. The rules actually provide examples of the types of language they want to see in contracts. They don't mandate that language. You can pick the language that fits your purpose, but the DOJ is going to want to see those contracts to ensure that this data security program is a part of your overall thinking.
Okay, great. And then again, we talked about doing the mapping and the risk assessments, make sure you have, a compliance and audit program. So again, when you look at the pillars of effective compliance program, not only do you need to have these risk assessments, most likely do this data mapping so you can actually comprehend the risk that you're controlling around, but have a compliance and audit program. So, have these not only the first line of defense, which is, your business, but the second line, which includes your compliance program, and the third line, which is your audit program. We talked a little bit about training and monitoring data flows, and considering applying for licenses if needed. So before we turn to Q&A, Ross or David, do you have any final words?
No, other than I urge everyone to, take this seriously. I think the department and this administration are going to use these rules to achieve their goals. Obviously, we've all seen the news, about issues with Iran. And so, for example, it wouldn't shock me in the least to see this department try to identify U.S. companies that either do business with Iranian companies where data is shared. I suspect there won't be that many of them, but U.S. companies who share data with third parties who then share that data with Iranian actors who might use that data to harm American interests. So, there's I think there's a lot of different ways this may go. I think we're going to learn more in the next couple of weeks, but yeah, we're here if you need us, and it's been a real pleasure, Brad and David, talking about this interesting program with you both.
Thank you, Russ.
Yeah, and I would add to having been outside counsel for the last 15 years, and I would say it's not just, we've talked a lot about things in looking back and creating things of information that we already have. But as part of your compliance program, your data governance program, setting up those processes for moving forward as well, making sure that when new systems come online or new business processes are created, that you're also accounting for these rules and the data flows as well, and having that, not having that ability to understand when those systems come or when your business gets into new data transfers in new countries, that you're aware of that and accounting for it in your program in the future as well.
I appreciate that, David. So we do have a question. So Ross, I'm going to give it to you. Can you comment on the requirement that the transaction must be a covered data transaction, which means data brokerage or a vendor agreement? Does that limit the scope of the regulations in any meaningful way?
Yeah, it's a great question. So what the regulations say is that there are 4 types of agreements that are covered. A data brokerage transaction, a vendor agreement, an employment agreement, or an investment agreement. I think the one that's going to come up most often is a data brokerage agreement, which the rules define basically is just any company or entity, individual providing data, access to data to another company where the receiving company was not involved in the sort of creation of that data. So it's a pretty broad definition. Does that limit the scope of the regulations in any meaningful way? Yeah, I guess theoretically, you could have a different type of arrangement with a foreign partner that involves the sharing or providing access to data. But I have a feeling the department would argue that any sharing of data like that falls under the rubric of a data brokerage transaction, no matter what you call it. So, short story is, again, I hate to dodge the question. Everything is so fact specific that if there was a certain arrangement that a U.S. company had with a foreign data partner, that we were to take a look at, we could assess whether or not it falls into one of those 4 categories. But I suspect that most data sharing agreements probably will.
Appreciate that, Russ. So do we have any other questions that people would like us to answer? All right, so Russ, one of the things that I want to go back to, and Dave, maybe you can chime in on this, is Can companies use third parties like ours to help with the data mapping, the risk assessments, or the audit, or even put in, a compliance program, or, come in and do a compliance gap analysis, or do they need to do that through internal programs?
No, not they absolutely can use great companies like Guidepost or law firms like Steptoe. And again, I would urge companies to do that. And the reason is not only because I think it'll be really effective. I think having outside counsel or investigators come in and do these exercises oftentimes can be helpful. I also think it's a really good idea because hiring Guidepost to do this will allow a company to then turn around and say to the Department of Justice, if you ever get a letter, hey, look, we're already working towards coming into compliance, and here's the proof. We've hired, David and Brad to take a look at our data and ensure that we're following all these rules. So I think that hiring Guidepost is absolutely what companies should be doing right now. Again, not only because you all are going to do a great job, but because it's going to signal to the regulators that a company is taking this really seriously.
Appreciate that. And usually, how we prefer to structure those is through something called a Covell agreement. So there's a court case called Covell, and what Covell says is that if a law firm or attorneys engage a company like Guidepost, that the work that we do and the communications in front of that work are protected by the attorney-client privilege. So David, I don't know if you want to chime in on ways that Guidepost can support risk assessments or data mapping or audits, and how we can work with a terrific firm like Steptoe on accomplishing clients' objectives.
Yeah, no, I agree, and I think Ross put it really well. I don't have too much to add, but except to emphasize the point that he made. I always found it helpful at the various companies I was in house with to have that third party come in, and so that I could, as you said, Ross, turn around and say, "Hey, I do take this seriously. I have put the money and time into it, and to develop this program, I am looking at it." Yes, depending upon the size of my organization, it may take a little while, but we are getting there. And here's our plan. And what we've done at Guideposts, and we've done this work. We can create these plans, and so that you have that information up front. If you happen to get an inquiry halfway through implementation, you can show roadmaps and show what you are trying to do, as Ross mentioned earlier, to help with those mitigating factors, or to be a mitigating factor.
All right, terrific. All right, so just want to make sure there's no other questions before we conclude. Give folks about 15 seconds to populate the question box. All right, terrific. So I want to thank both of our panelists for joining us today. Ross Weingarten from Steptoe. If you would like to get in contact with Ross, his email address is rossweingarten@steptoe.com. It's at the bottom of the slide. David Moncur from Guidepost Solutions, which is dmoncur@guidepostsolutions.com. And I'm Bradley Disick at bdisick@guidepostsolutions.com. So feel free to reach out. We're happy to answer any of your questions. And if you ever need support, with prevention or response, we're available. So thank you again for attending, and it was great to be with you.
Thanks, Brad. Thanks, David. Thanks, everyone.